Hi, I'm Matthew Miller, Managing Director of Motoring Offence Lawyers. One of the most common types of inquiries we receive here is from people who are at risk of a totting up disqualification due to the number of penalty points on their licence. So normally they'll already have 9 penalty points on their licence. They've been summoned to court as a result of being accused of another minor speeding offence or a red light offence, which means they're at risk of a totting up disqualification due to the fact that they're about to reach 12 penalty points. And what people often ask me is, what can I do to save my driving licence in that situation? The starting point, as far as the magistrates court is concerned, is that they must disqualify under normal circumstances for at least 6 months. The only discretion they have is if they find there are exceptional circumstances that would justify a deviation from the normal sentence of a 6-month disqualification. So if hardship is being relied upon, it's necessary for the person who is in court to establish that that hardship is exceptional and goes beyond the normal hardship that would be caused to the vast majority of people who rely on their licence in some capacity to do their jobs, for example. So you really need to be in a position to show that the type of hardship that you would suffer from goes beyond the normal hardship that would be suffered by the vast majority of other people worthy to be in a similar situation. One of the ways that I explain it is by saying if I was to be disqualified for 6 months, it would cause me a lot of inconvenience. But in all honesty, it's not the type of hardship that I would consider insurmountable. I might have to perhaps get the bus or the train to work every day. I might have to perhaps leave the house a bit earlier in the morning. But I'd probably just about be able to get by. So in order to be able to rely on exceptional hardship, you need to show that the type of difficulty that you would suffer from goes beyond that normal inconvenience that I would suffer from. So if you're employed, it's always a very good idea to obtain a letter from your employer explaining how important the use of your car is to being able to do your job, and the fact that if you are disqualified, it's highly likely you would lose your job as a result. And what it's also very useful to establish is that it's not just you that would be affected by the disqualification, that there are other people who would be affected. That might just mean other employees who would suffer from the knock-on effect of you losing your job. But more often than not, it will be that dependents would suffer as a result, people who are completely innocent as far as the commission of the offences are concerned, but are going to suffer adversely as a result of the disqualification and the ensuing loss of livelihood. Because magistrates are much more likely to be impressed if you can show that the exceptional hardship is not just confined to you, the person who is being punished, but is also going to be suffered by other people